Good morning, everybody, and welcome. I'd like to call the meeting to order. It's currently 10:03. Can we call the roll, please?
Chair Jean Embler.
Present.
Vice Chair Christina Ponte. Christina Lockhart-Wells. Judith Ann McLaughlin. Paul Tilka.
Present.
Give Claire a minute. Good morning. So I'd like to hear a motion regarding adoption of the minutes.
I'll make a motion to approve the minutes.
Do we have a second?
I'll second.
Okay. All in favor?
Aye.
Aye. Okay. Okay, our agenda talks, the first thing is to continue our discussion about the draft working document. Before we go to that, I was hoping that we could get an update from Robin. Maybe, Sean, you can address this in his absence. Sean had committed to get back to us regarding the city's current practice of drug testing all employees. What's the status of that?
Currently, we're drug testing everybody.
Okay. And Sean had committed to look into it, and as I recall, he stated that if this is in violation of any state or federal policies, that would no longer take place. So I guess I'm asking for an update.
Okay, so the update is more or less the same. Our insurance company requires us to do it. So it's a decision between, it's actually probably a decision for Robin, but he agrees that everybody should be drug tested. We'll lose our discounts.
Okay. I'd like to just take a moment, if we could, please. I personally understand and respect that we want to be fiscally responsible, but I am concerned that we are not acting according to the law. I would be curious to hear what my fellow committee members think about this.
Yeah, I watched the recording of the last meeting, and it sounded as though he was going to get an update from the insurance company to find out if there were any alternative options, to work within, no, not you.
Oh, okay, I'm like, wait a
No,
minute.
you did not commit to that, not you. Robin was going to get updates and see if there were, is it a discount for being a drug-free workplace? And is there a way to work within, maybe there's a way, my understanding was the insurance company was going to be asked what gives.
I don't know.
Okay.
I'm sorry.
So I would say that falls back on Robin. And
Paul?
I agree. I think it definitely needs looked into, and we don't have an answer available right now, so we should definitely follow through.
I started thinking about it. Maybe there's a way you can say that, here are the jobs that are safety sensitive, and these are the ones that, to work within both confines, getting your discount and testing based on it being safety sensitive. I think also random drug screenings are allowed during work hours, so maybe there's some combination.
No, we only do drug screens post-accident after you're hired or reasonable suspicion.
But we need to be following the letter of the law to be the city safe, I would say, as far as, actions against us.
I agree. I think it needs resolution, so however we go about that, I don't think we've gotten feedback on it.
But why isn't, a lot of this, like, in the law and boilerplate, that we can just accept it as that's the way it is? Or, if it's the law, if it's state law or federal law.
My understanding from Attorney Rob is that he has made the city aware, but just like us, we are advisors, but it's up to the city to make a decision, and the city has opted to take the insurance discount rather than follow the letter of the law. Did I state
Yeah,
that
well,
correctly?
And that wouldn't be proper, I don't think.
And I actually had
It
a
just-
question. I reviewed the charter information that we were provided for the Civil Service Committee, and so maybe I need to dig further into the charter. It seems to say, that we shall prepare personnel rules. When concurred by city manager, the rules shall be proposed to the Board of Commissioners. I didn't see anything that says when we're not in concurrence. Does anybody know how that, because this is a case where we're not in concurrence, how do we handle that?
Before we go to next steps, Judith, did you want to weigh in on this?
I concur with the other board members that we need to find out more information from the city staff, and then we can take a vote on that. But I think, in answer to your question, I think the Board of Commissioners has the final say. So they don't have to we're advisory, as far as I understand.
And so we're all in agreement that we're not comfortable with the way the city is pursuing this. So I wish Robin were here, so now we've got to decide how do we want to proceed. The options, as I see it, is to put it back to Robin, but I would prefer to not wait 3 months to get an answer. I feel like this has been out a long time and we've not gotten an answer. So option one is to give Robin a chance to get back to us sooner rather than later, or I feel compelled to advise the Board of Commissioners of this situation. Yeah, Clara?
And what we can do is, we have a person in finance that communicates with our insurance. We can try to get something in writing to give to the city manager to provide to you all.
Okay. And when
From
can
them.
we get a written response?
We'll try to get that done this week.
Okay.
I don't think they're going to write down, like, don't test everybody. I mean, that goes against everything that
Oh,
they.
okay, if possible.
Well, I would like a written response of what is the city's position, and then I would like the attorney to provide us the the statutes that address either federal and/or state policy on drug testing. And then depending on what the city says, we can take a vote on whether or not we feel we need to take this to the Board of Commissioners. Is that-
I'd also recommend that the insurance company be questioned, because maybe there is a way to still receive the discount while, no. that's-
Unfortunately, no. I did
Okay,
speak with them when
you
I
did.
first started,
Okay,
because, I mean, obviously it's a conflict.
sure.
And they said if you don't test everybody, you'll lose everything,
Okay,
as far as the discounts are concerned.
okay. Yeah,
Thank you.
yes, thank you.
And I think that's
and-
going to be their stance going forward, but we can certainly reach out to them.
Good, good. So, I mean, we are the advisory board, and I feel like we're doing our due diligence, and ultimately, it's the Board of Commissioners that's going to make the ultimate decision, and of course, we will respect that. So, okay, thank you.
I would like to maybe inquire as to what line of insurance we save money on, whether it's liability or whether it's the health policies or,
I can tell you that it's workers' comp. As
Workers'
far
comp.
as other stuff, I'm not sure.
You have a dollar amount, Sean,
A dollar amount? No, I don't.
of savings? That would be important to know as well.
I think it's
please.
5%.
Which equals about,
I'd have to look it up.
okay. I'd appreciate if we could get that dollar amount as well.
5% of the overall amount?
Of the workers' comp insurance, as I understood it.
Okay.
Okay, thank you. One other piece of new business before we go on talking about the document, I just would, again, respectfully request that we receive the minutes of this meeting 2 weeks after the meeting, so that the content is fresh in our minds. Receiving it 2 months late is, it's a challenge for me to remember everything, I'm being honest. So I know the city had stated that they would do it in 2 weeks. If it's 3 weeks, okay, but if it's 2 months, I'm challenged by that, and I ask that you stand by your commitment to 2 weeks.
Okay, we was thinking that it was 2 weeks before the packets go out, because for you to read them in the packet. So we'll do that, and they'll also be they have to be included in the packet.
Right.
As well.
That's good. I would just,
Okay.
well, we're covering a whole lot of ground here, a lot of small details, and I just can't count on my memory, and I'm
Yes, I
counting on you to help. So, thank you,
I
Clara.
face that too sometimes.
Yeah. I have a big birthday coming up this month, so I'm entitled to be worried about this. Okay, any other new business? No?
Well, are we going to do old business?
Yeah, you said.
Or old, I'm
you
sorry,
said
any
new,
other
you said-
old
do you
business?
mean old business?
Any other old
Well,
business, yeah.
I would
Yes,
like
Bob?
to bring up something, but I think Rob should be present for my inquiry, but Mr. Trask may be, I'm sure, able to answer the same question. But on page 2 of our last packet, I had asked a question to Mr. Eisenfelter, asking, are our employees of the city protected by the Civil Service Commission? And he stated no. So that's the first inquiry, is how are they not protected by the Civil Service Commission? But it goes on to, he went on to state that under the charter, the Civil Service Commission is an advisory to the city manager, period. Under the city code, the Civil Service Commission does not have subpoena power. I'd like that explained a bit. I've read the city charter and I've read the code. Do we have any comment?
So just tell you who I am. I am the interim city attorney. I'm sorry, we haven't all met before today.
Yes.
I'm covering for Rob. He should be here in another 5 or 10 minutes.
That's fine.
He's running late, and that was the reason for me stepping in, so you didn't have an empty seat. As for his position on those 2 items, I think we'd probably be best for Rob to explain those to you. I don't know the answer to those questions.
Okay.
And what his thinking was. I did read the minutes, obviously, and understand where you're coming from, but I don't know the answer to the question, and maybe when Rob gets here in a few minutes, he'll be able to respond to that. So maybe if we can move that question to the back end of the meeting, if that's okay with you?
That's right.
Okay, all right.
Paul, can you better explain what you mean by, are the personnel protected by the Civil Service Commission? I mean, should they? Is that what you're implying? Should they be?
Oh, I am implying they should be.
And they, in other,
In past experience that I've had on this commission, I haven't seen that as the practice. And I did bring one of the cases up to Rob, and he was going to read it a bit, so I just don't know where to go from here, but I see there's a major flaw that we'll address when we get to down the road here in our work. So it's when it comes to discipline and what have you, so.
thank you.
I've made a note of it, and so if we don't capture it because we kind of lose track of it today, I will talk to Rob about it and see if we can get a response to you if it's not covered today. Okay, thanks, Mr. Tilka.
Any other old business? Okay, shall we dig in? John, did you want to go ahead and lead the
Yeah,
discussion?
I'm sorry I had to step out. Did you guys talk about the ordinance at the beginning of your suggestions?
Okay. So I guess we have
you want
in
me-
our packet the updated policy, and then behind that, on page 57, are my comments, and then we have the Safety and Accident Prevention Manual. And I was questioning the clarification about an ordinance that was referenced on page 141 of the attorney version. Yeah. Get that. All righty. I don't think that that was included in everybody's packet. Was it?
Don't think so.
Okay.
On the ordinance. It was an ordinance that hadn't went to the Board of Commissioners yet, but it'll have a 2022 number. It's on whistleblowing. And
Yes.
so when that gets adopted, it'll be incorporated into the personnel policy, and that's where it'll reference the correct number.
So the page 141 in the attorney document references ordinance 2020-17, but you're saying that that was not adopted. Is that right?
No. it
Okay.
wasn't. No.
Thank you.
And
for
we
that.
didn't, there wasn't 142 pages to the we was trying to find that page.
I can give you my copy, and you can make copies of it. So that was, yeah, it has to do with whistleblowing primarily. And where does that stand? Is it in front of the Board of Commissioners at this point or not?
It's being prepared for the commissioners.
Right, it has been prepared?
No, it hasn't gone to them yet.
Okay,
That's an upcoming ordinance for this year.
okay. In fairness to Rob, I'd like to circle back to that when he gets there to understand, is the city at risk if we don't, pass, if the Board of Commissioners doesn't pass this ordinance? You know, what prompted him to include this language? Is there risk or what?
I think we're
What's the sense of urgency?
Yeah, I'm thinking we're automatically under state law as far as that. It was to be just included in some language. My understanding from the HR director, there is something about it in the policy, but later on.
Okay, okay. And I will, at the end of the meeting, I'll give you this so you can have copies of it for your record. Not sure how I got it, and you guys don't have it, but anyhow, thank you. All right. Christine, did you get a chance to submit comments?
I didn't. I wrote them in my notebook.
Okay.
I have some general comments. I went through everything, but so one question I did have was, what is the process from, so we're shooting for September, right, to complete our review?
Mm-hmm.
And then after that point, is the city going to make the recommended updates and then we're going to discuss again? Or do you know, Jean, what the process?
September was just the goal to start the new one with the new fiscal year. It's not set in stone.
That's what I was wondering.
You know, we have time. We've actually done more work since we've started than we did all of last year. So it's moving forward.
Good job, guys.
So I think as long as it's moving forward, we're good.
Okay. So, but once we complete our comments and submit them, would that be the next step, is to have the city make the updated? I saw that you went back and adjusted for the last meeting, included the comments. Is that what we envision, is going back through, or simply adopting what the updates are?
I'm not sure I understand.
I think what you're trying to say is, well, when you talk about the changes, he added those changes and
Yes.
strike out and underline. And then when the packet got published, you received those updates and strike out and underline. That way, at the end, the Board of Commissioners will know what was changed
Okay.
by strike out and underline.
Do we need to go back through and accept the updates from the prior meeting that they incorporated at some point?
My recollection is that Rob suggested that we just continue, and then.
At the end?
And then at
That's
the
what
end.
Okay, that's what I wanted
We go
clarification on.
through.
Okay,
And
at the end.
that was my recollection. Anybody have anything different? Okay. All right. Did we get through Article 6?
The last notes I saw were Article 5.
Right. And I had previously submitted comments on Article 6, so they're not in this packet. So it would be in the previous version. So it's my understanding we need to carry on with number 6, is that right? Okay.
One general comment, is there, I don't see it, is there a statement in the general provisions that states that where not defined by this personality or personnel policy, the default is the law, and should that be considered for inclusion? Okay. I just see a lot more in the other version, a lot more specific statutes that aren't called out in your version. I don't know if that addition would, I can just submit that in writing and it can be considered, but it would give the reader the knowledge to always consider that if they find a lapse in the policy.
This is why I need the notes 2 weeks later. Article 6 has to do with benefits. Okay. Let's just take a minute, review our notes, allow Rob to get settled, and, okay. Sean, I'm looking at the minutes, and I see that we have published minutes through Article 5, but I don't see anything on Article 6. And in closing, it states the consensus was to begin with Article 6 at the next meeting. And if they do not get caught up to where they should be, they will consider adding a meeting. So I think our starting point for today is Article 6.
Okay, I have your comments from the last time for Article 6.
I had submitted comments prior to the meeting, but we ran out of time to cover them.
Okay.
Okay? So, Rob, welcome.
Hi.
Hi. Are you okay? Do you need a couple minutes?
No, I'm good.
Oh, okay.
Had a dog try to eat my leg this morning.
Oh, my goodness.
Yeah.
How's your dog?
No, it was somebody else's dog.
Oh, okay.
I was out walking a dog, and one of my neighbors walking by the other way, and hi, and
Yeah.
next thing you know, she charged me, grabbed a hold of my leg, and
Oh, no.
stitches. Yeah,
Oh, goodness.
Stitches.
yeah, it was a big dog.
Yeah.
Oh,
Yeah.
Thank
yeah,
you.
glad you're
thank
okay too. That's scary.
So,
She's a vet,
Oh,
oh, my.
and she's scared that I'm going to sue her, and I'm like, I'm just a lawyer.
This sounds like a bad joke. a veterinarian and a lawyer were walking their dogs. I'm sorry. Paul had brought up a couple of questions, and Tom wanted to wait until you got here. Shall we cover those before we jump into Article 6? Okay?
Can I go ahead? Oh, so Rob, at our last meeting, I asked you a question about whether our city employees were protected by the Civil Service Commission, and you made a statement, no. Do you recall that?
Yes.
So how are they not protected currently?
Well, so first of all, what I hear from your question, or what I read into your question, is, does the Civil Service Board have the power to put people back to work if they feel that they were terminated wrongly? And unlike other civil service boards here in Pinellas and across the country, really, that do have that power, you don't have that power. You're just a recommendatory body. So as I read the charter and the ordinance, your role is more of a advocate, if you will, for the employee as well as, I don't want to put it as a us versus them kind of thing, because you also have a very important role to be a positive voice of helping management develop these rules. I mean, that's part of the function that we're going through, the exercise we're going through now, and it is hoped that process can be as cooperative and collaborative as possible. But then once the rules are established and management starts to enforce them, the employee does get to, in a discipline case, does get to come before you all to argue, why it is that they didn't deserve the discipline they received or whatnot. But at the end of the day, you're still advising the manager, and it still is the manager's final decision to do. So if that's what you mean by protect.
Protect, yes.
Yeah.
So, but to carry on, I think you commented, under the charter, the Civil Service Commission is an advisory capacity, and I did read that. But under city code, the charter does not have subpoena power. I think the charter reads differently.
In the city charter, there's subpoena power.
Yes.
And then somehow in the code, it says, I guess it doesn't mention it. Or it
Code?
says you do not.
I don't think the code talks about it either. I have both here.
I don't think the code speaks to it. I'd have to pull it up on my iPad,
So-
but I think the charter does, and so the charter says you have subpoena power, so you certainly have subpoena power. You just don't have power to reverse a discipline decision.
Okay, so we have the authority to hold hearings as such.
Correct. You can subpoena whoever you desire to subpoena. If they don't come willingly, then you can issue a subpoena, and the sheriff will go out and enforce.
Okay, so that's basically covered, because that's the way it was in the past, or my experience with it, so that's well and good. What else was there? So, well, when we get to the, if you recall, last meeting, I gave you a paper of employees, written by an employee, I'll just put it that way. And at some point, I would like to have an opportunity to talk about that before we get into the discipline portion of our discussion. Because what do we do when otherwise procedures are not followed?
Well,
Like
so.
in that instance.
So again, under the charter, you have complete advisory role to the city. And so if this body becomes aware that you feel management is not following the current rules, not following appropriate employment practice or whatnot, that's all within your purview.
Right.
You can call a meeting, you can conduct hearings, you can require, if you will, although I'm sure management would willingly come, but you could invite, if you will, management to come and stand before you and for you to pose questions to management. If the answers you get from management are answers that you don't agree with or whatever, and again, your role really isn't to second guess any particular decision of management, right? But it's more of a policy thing of, I don't think management handles this well. I don't think it handles it the way a good employer should handle it, whatever it is, be it legal side or just be it best practice side. You then convey that to the manager, the way it's supposed to go. The manager could do one of two things. The manager could either say, you know what, you guys are absolutely right, we're doing it differently from now on. Or the manager could say, thank you so much for your opinion, I don't agree with it, I'm going to keep rolling the way I'm going to roll. At that point, you then make a motion, and if it passes, it's basically a resolution that says, we, the Civil Service Commission, decide or recommend to our city commission that policy needs to change. And we have asked the manager to do this, the manager has not done it, we're following our process, and we're now taking it up to the highest authority, which is you commissioners. Here's our recommendation. And then it's up to them what to do.
Do we need to include some verbiage as far as that process in our work?
You don't need to for it to be legally effective. I could certainly put something together that is more procedural in nature if you want, and bring it back to you next time. So
I'd like to see something in that vein, actually. Thank you.
Let me write that down.
Paul, is it your intent to revisit the situation that happened in the past, the one that you just sent him?
I think that was our other member, that's not here. Christine inquired along the way about maybe cases that would come before us, and I recall Claire sent out 2 hearings that the Civil Service Commission held, on behalf of the employees. And I think both of them they enlightened me to a whole lot. But
Can I ask if you guys, did you review them? I did. There were 2 cases, one in 2019 and one in 2018. I had actually asked that question, Paul.
Yes,
There was Miranda Bachart patent, and then there was Danielle Kaputsa.
Right.
Had you both reviewed those? You did?
Yeah, but see, I think at that point in time, I think the Civil Service Commission we ran up against a wall, absolutely, as far as cooperation, but.
I guess my question is,
are
you wanting to reopen these cases or?
I think a learning experience.
Yes, okay.
What I have in mind, because
Okay.
those people are gone, but I don't think they were properly treated, and I don't think procedures were followed, or progressive discipline and all this and that. It was just.
And we paid for it.
Yeah.
So and I said, ultimately the city paid for that mishandle So there were.
Well, I think they lost a couple of really good employees in both cases, but that's only my opinion. But I think a consensus at that point in time was, we had no further to go. The city manager reacted, and it was all over with. He didn't want to even talk to us.
So one thing I would like to understand from those, is everyone comfortable just discussing those? And for me, I would like to understand, I can only get so much from reading a 100-page transcript, but what the flaws were in those cases, and because I wrote down timesheets, pay for work hour, comp time, flex time, a lot of different issues came up, and I think that one was in 2018, one was 2019, and I don't know if additions were made.
Even back tuition owed, I think was part of it. It was a whole bunch of stuff. Really. Huh?
It was a lot.
A lot.
Had updates been made related to those two instances?
I don't think so.
Well, were you all involved on those as well?
No, it would have been, afterwards would be the city manager's office at HR.
And I think it was a different HR manager at the time, and
Sure.
so I couldn't remember who was involved in those, but it seemed as though it's the same policy, and it allowed for a lot of shenanigans to occur.
I do know that the Board of Commissioners discussed the issue at their July workshop, and it was one of the commissioners had asked that it be on the agenda. It was about if the civil service should reverse it, like if there was a complaint on an employee, wrongful termination or whatever, and at the end of it, their recommendation is that it's the fault of if it's a charter officer, they ask that the complaint against the charter officer at that time come to them. And that way it doesn't lay dormant and the charter officer doesn't determine their own fate. It comes to the board. So I would have to look at that, exactly what was said, and I can send you those minutes. And I think the city attorney had written something down that night about it. I have to check, see what's with that.
So I think that as we discuss all these things, I wasn't here, unfortunately, I had to travel for work last time, but we went through a couple of things that I don't think were discussed in the context of those cases, including the, employee complaint processes to come, termination, but things like flex time and compensatory pay, you guys went through that. I don't know that we discussed it with consideration that it's been an issue before. And the policy, do you feel currently, and the policy has to marry what gets done, is there a good way to know, because what happened in my reading, and Paul, please tell me if I'm wrong here, but she had thought she had compensatory pay for being called back, and also compensatory pay for, she said, I had 2 hours for being called back, and it didn't show up on a timesheet anywhere. Paul, I don't know if you reviewed, but that doesn't seem to be addressed.
I don't have a good recollection of that.
I read back yesterday in preparation, so that was, there are different things that I think we ought to consider from that case, as they were both related to this policy. And
okay. This was the, I'm trying to think which case.
Kaputsa?
Yeah, okay.
Kaputsa?
Yeah, at that point in time, it didn't seem the city had any policy.
Okay.
That people were just signing in at will, just the way they clock their hours. And so we did make a recommendation, and I do think that the department incorporated a time clock or something for registering the time.
We do. We have electronic
clock.
time.
How do you deal with?
Before then, it was just,
It was all,
yeah. And here the girl gets called down for not doing the same thing everybody else was doing.
Okay. So you guys think that the current timesheet, flex pay, all those are well managed and manageable for you guys?
I think they are.
Okay,
Yeah, there's been no issue since I've been here.
okay.
Well, maybe we solved something.
Yeah, you sounds like you did.
Like, there was an ordinance that was passed in August of 2019, which should have been after those cases. So I guess I was wondering if the ordinances, it says related to compensatory time, pay period, and paychecks, all of that, there was a recent ordinance, so maybe that was intended to,
Oh, there's
to
a recent
change.
ordinance that may not be reflected in the current policy we have.
I think it is reflected.
Oh, it is.
Like if you look on page,
Oh, let me get.
like the section, okay, hold on, I'll just say Article 4, Section 405, 406, 407, all say ordinance 2019, from August 13th of 2019. So that all is after the two cases you're mentioning. So I guess my question would be, maybe there was attempted changes in the policy to address those concerns.
You said 405?
Yes.
My understanding of what that ordinance is we had a Civil Service Commission, which Paul Tilka was part of. The policy that the city is using now is the one that they wrote, the Civil Service had written in 2019, and it's adopted by ordinance, and it was in 2019.
So my assumption is that there were changes to address the issues that were brought up by those cases. Would that be a fair assumption?
They worked about a year on this, didn't you?
I would say on this case that it was, yeah, the city did take action. They installed a time clock of whatever sorts, rather than just the person going online and checking in that way.
We used fingerprint.
Fingerprint.
Yeah, you had to
Now?
go to the clock.
Oh,
Yeah,
oh,
clocks
that's
were
really
in and
good.
out.
That's better than I expected.
And you can also clock in on your cell phone, but it tells you where they are when you clock.
How do you handle tracking like callback time? Is that handled? So that was a specific instance where she said, I was called back, it was only 15 minutes, but the policy says that I get 2 hours.
Yeah, it's whatever, I know it's in here somewhere.
It's right above Section 405. Callback. Any employee that is called back to work
Right.
will receive a minimum of 2 hours' pay, as outlined in their respective collective bargaining agreements. Calculation of overtime will only be considered after first 40 hours
Right.
worked in a
What-
7-day
What I'm
period.
stating is that this became an issue in 2019 when it wasn't recorded by the manager because she said, look, it says it here, but there was no tracking of that. So I would recommend that that be addressed or you might already do it. I'm wondering if the city currently tracks when somebody gets called back and gets comp time.
The department heads typically take care of that, but I'm not aware of anybody being called back.
This
Since I've
woman
been-
was saying, well, like, I had to go home for whatever, and then I got called back to work at the volleyball court or the wedding or whatever. I was a little confused what she was doing. But so are you tracking comp time? And is there a standard procedure for logging compensatory, get callback time, these different efforts?
There is, like if my employee
Okay,
has called, they have to actually, again, punch in.
send it to you. Okay.
It's all there.
Okay.
And anything after 40 hours on there, they usually just take a half a day on Friday or, and it comes out to the 40. We have to control that where it doesn't turn into overtime.
Yes, ma'am. So that's tracked. That
It
was
is.
my question.
It's all
If-
electronically through the Paycom system.
Okay. Thank you.
Do they enter a code when they touch their finger? This is callback time?
They have to actually code it, and the supervisor approves it.
Excellent.
If they're out sick,
Okay.
They'll have a sick time in there, and the supervisor has to verify that and approve it, whatever. And if it's after, it's going to be 3 days or whatever, they're required to go to have a doctor's note. And it's
Excellent.
all tracked. It's a wonderful program. Everything is
Excellent.
tracked.
It's much better.
Is
Okay.
it Chronos? Just curious, is it
It sounded
Chronos?
like
No, it's called Paycom.
Paycom, okay.
Yeah.
And when was this installed, Paycom system?
October of 19,
Okay.
I believe.
Thank you.
Or is it 20? I don't know, 19 or 20, I'm not sure.
It's 19 or 20, because we had to get bids. HR, we had to get bids on it.
I think it was later than 19, I think it was 20.
Yeah, it could be right.
Okay. So it's fair to say then that the system was implemented as a result perhaps of these cases, and that you feel comfortable that we're tracking appropriately?
Oh, yes, I love it.
Yeah, I do too.
I love it. They put in way in advance. We have time spans for like requests for vacations and time off or whatever, and all that's in there. We're alerted through the system. We go in and check to make sure, you know, it's okay, and they got the time available, and, you know.
Is it approved weekly?
It's just whenever they put it in. They can request it. They have to request it through the system.
Like, so my timesheets, I get a weekly approval by my manager, and, okay. Because this was like 2
Same
weeks,
thing,
and,
yeah.
you know, and it seemed like there was a lot of ambiguity as to when people submitted.
Payroll doesn't happen until everything's signed off.
Okay, excellent.
Right.
That sounds like you guys make
Yeah, I
big
get an
improvements.
alert.
Okay.
When
When
Laura
she-
puts in a request for time off, it sends me an alert. I know.
Fabulous.
I think to some extent, you know, that those problems in that case developed, it was a whole different cast of characters. You know,
Sure.
you had a different manager, you had not really somebody who was even, you know, she performed HR, but I believe her main function was finance. Was that the?
Correct.
You know, so it was sort of, she always struggled to pick up the HR side of things, and it's a cultural thing, you know, if the leader at the time does not, you know, sends off a signal that we don't have to follow the rules, or the rules will be subjectively applied as I deem on any given day when I roll out of bed, you know, then the lower management people can get intimidated by that, and so can employees, but all of those people have moved on, you know, and you also have a dynamic of, back at that time, you had an outside, well, I'm outside too, but you had a completely separate labor and employment law firm over in Tampa. They were very disengaged, you know, and I more interact with the city, you know, we are the city attorney, our whole, you know, we're providing all services to you now. So there's also a component of, you know, I can see and hear more of what's going on, and if a problem looks like it's bubbling up, management will call me to talk about it. And, you know, my feeling is if it's discovered that you've done something wrong, especially in paying somebody, you need to just make it right away, because, I mean, there's not only Fair Labor Standards Act lawsuit that you can have for failure to pay overtime or minimum wage, but there's also a Florida statute 448 point something, 105, I think, an action for unpaid wages. Pretty sure, it's a couple sentences long. It says, if your employer doesn't pay you wages that they're required, you sue them and you get your attorney fees if you win, right? So why would we pay attorney fees? You know, if it can be demonstrated the person was owed something, be it callback or whatnot, just pay them. You know, it's, in the long run, it's the way to go. So I don't foresee all that to say that this scenario that occurred would occur under the team that's here now.
So one thing I'll add to that, though, I plan on staying in Madeira for a very long time, and as we know, characters change, and so the policy needs to be written to protect when X, Y, and Z leaves in, 2 years, and we're, so we want to write this so that it protects us, all of us.
And
yeah.
To your point, we could write anything we want,
Right.
and if a supervisor doesn't follow it, that's when we get into trouble. So I think one of the things that was missing prior was the tools to
Okay.
track and things like that. So I think we've closed that loop. But,
Yeah,
I mean, if we have a bad supervisor, we have to deal with that if they're not following the rules.
Yeah, and I apologize if some of this is rehashed, but it seems like it's not that recent past, so I just wanted to understand what, how this came about. It sounds like the timesheet and all that has been addressed. Paul, were there other things that came about from that aren't addressed or being considered?
Well, the one thing that I didn't see was any attempt at a progressive discipline that should have been followed in that case, so.
But it is in our policy book.
Yeah, and it was then as well, so.
Yeah.
But it was just, I don't know.
There's a discrepancy between,
You only get to know so much.
Sure.
should we jump to that section since it's following with the conversation, if you're okay with it? So there is the progressive discipline policy.
What article and section are you referring to?
Oh, it's at the end somewhere. And so there's a difference in the approach, here it is. Article 10, disciplinary action. So that, 10, and so there are different levels of offense, which I think closely reflects what that the attorney had also have, and I think this seems to be pretty common throughout. I think that all matches. One of the things that is different, I had differences. Actually, that was in the employee complaint procedure. The complaint procedure in this policy goes from manager to, now,
Yeah.
it goes differently than recommended by the attorney, and I don't know if that's worth discussing. It's actually a different article, though.
Where are
What
we?
article are you in?
Give me 1 second,
Oh,
please.
sure.
And then there's grievances, so that was the one I'm looking for. So those two are closely reflected in this.
9 is the grievances, Article 9.
What is it, 9?
Article 9.
Thank you. Oh. Classified employee appeals. Okay. So this one says supervisor, department head, and then civil service, whereas the other version, the attorney's version, had a different sequence. It did not include the civil service at the end, which I thought was interesting. And I was wondering if maybe we can discuss why that was and what the recommended, why you have 4 steps. The next one is HR.
I'd like to pause for a moment because we're jumping ahead to
Yes.
a section that we've
Okay.
not been tasked yet.
Okay,
Can I
sure.
recommend that we stay when we get there, but absolutely focus on this when we get to number 10, just so we can be more methodical?
I'm okay with
Is that,
that.
we okay with?
We'll just retain
Yeah.
that for
And then-
that conversation when we get there.
Christine, I read the, what
This
happened, but I
case.
didn't take as many notes, so I appreciate that you did that.
Sure.
And please,
Oh, yeah,
anything
I'll-
that specific as we get to that.
Yes.
Thank you for doing that and remind us.
Yes.
Okay.
I would recommend, if everyone hasn't, take a look back, and it's just, it's not that recent past. I think it's the same policy, and we want to make sure that we are protected from, something like this happening again. It sounds like the timesheets are fabulous and has resolved some of that, but,
Okay, then, picking up where we left off from our last meeting, Article 6, benefits. I had provided written notes that were in the package from before, our meeting before, but we didn't have time to cover it. So what we've done in the past is take a look at what was written and then open it up to anybody else that we want to go through article by article. My general comment about Article 6, I stated, as a general observation, the benefits section of the attorney draft document has 30 pages, while the city has 5 pages regarding this topic. And I asked what prior discussions have taken place between the attorney and the city to identify differences and best practices. I guess it just, to me, benefits are important to the employee, and are 5 pages sufficient? What's missing? I did have specific examples, but I would like to hear about prior discussions between the city and the attorney.
they're structured differently. I'll add,
Yeah.
I tried to compare one-on-one.
Yeah, I tried to do the same, and they're just so different.
So the attorney's version includes the disabilities and workers' comp. It also includes more information on domestic violence is not included in this at all. Not domestic leave. Oh, you added it? Oh, sorry. Well, so there's comment about violence. There's comment about domestic leave in here? Domestic violence leave?
It's in blue on today's.
Okay. 607, you said. Okay.
And maybe because my, that comment is just in general, let's hold that thought till we go through each of the specifics. My second comment before we get to the different sections, I say both documents have different, and I call them buckets for vacation, sick, and floating holidays. And this is a question, is this typical for municipal governments? Every place I have worked, we've combined everything into one bucket called PTO, or paid time off,
Every government agency I've worked for has the buckets.
the different ones.
Yeah.
So you're saying that's best practice in municipal?
Yeah, and PTO has its own issues too, because employees tend to come to work sick because they want to go on vacation.
Right.
So it just, spreads germs and sickness and all that kind of stuff.
Okay.
Different employers do it differently. I recall when I was with Manatee County, Sarasota County converted over to what it called uni time, which is basically, we're not doing sick vacation anymore, in part because you get the thing where people get it in their head, well, when I leave, I get paid out my vacation. I don't get paid out my sick. So I'm going to try to use sick for something that really isn't sick. Or there's all kind of games that are played, and there's the whole, I don't want to burn my leave, so I'm going to come in, with the flu or whatnot. And so it can make, from an administration standpoint, it can make things a lot easier to just go to a paid time off. And, you're an employee, here's our calculation. For every hour you work, you get 0.124, accumulation of paid time off. Whether you want to use that time off because you got the flu or because you want to go to Disney or whatever, it's your time to use. So it's really a philosophy of how does it work in a particular culture. And so, I think management is comfortable the way, it's been done now. It doesn't seem to be hurting the organization the way it's done now, so.
Has it been discussed as an option? Yeah, doing it that way instead of the.
We haven't discussed it. I mean, I think the management and employees are happy with what.
They're happy with them, and there's no.
Okay, I'm comfortable with that, if it's, thank you for that clarification. All righty.
And one, so where are you? Because I did have a question on 601.
Yep, those were just two general observations. Now, go ahead with your
Yeah,
comment on
six-
let's go section by section, and starting with 601.
One question I had was part and full-time shall receive either 8 or 4 hours of holiday pay. What does that mean? It's
Part-time, you receive 4.
Oh, okay.
Okay.
I think that sentence could be restructured for clarity. And full and part-time. I'll just mark that. Okay, that addresses it.
I think it goes on to say part-time employees get the 4 hours. So I think it's in there, yes.
8 hours or 4 hours at regular addition to
Next paragraph down.
part-time employees.
My comment.
Then why would you, then I would remove the part-time from this.
Yeah.
That it's confusing the way it's written.
So I think to be productive, I think if any commissioner or the full commission feels that something should be rewritten, clarified, or whatever,
Consider.
it's better, right now you're making a comment, and staff is sitting there quietly. So I think what needs to happen in any of these things is you need to say, staff, do you see where this could be rewritten more clearly? They will say yes or no. If they say yes, you say, will you commit by the next time you bring this back to rewrite it to where it's more clear? That way, everyone can take notes.
Okay.
Because if you just sort of make passive comments, we're not really going to
Will you
get.
consider rewriting that sentence to make it more clear? I can see the ambiguity in that and redundancy.
That's not a big deal. Sure.
Okay. Thank you.
I had a thought in 601. It says full-time and part-time employees required to work on the holidays shall receive either 8 hours, et cetera. Does this apply to exempt employees as well as non?
That's somewhere in here. I think the city manager has the ability to give them a day off if he sees fit. It's in here somewhere. I'm not sure.
I think that should be clarified, and if it's arbitrary by the city manager, that could lead, I think, to favoritism. And that, so I'm making a request that that be clarified as to how that's applied.
So again, I think you need to get it on record that staff is agreeing with that and committing to make that change.
Yes. Okay. Thank you.
A question, which I don't think this is just for a quick discussion. There is taking another day off with pay. Never mind, I strike that. Never mind.
All right. I'm still in section 601, and I said, please consider including the attorney draft document language on page 44 of his document, clarifying rehire eligibility for personal holidays. That would have been back in the attorney version.
Oh, we're on.
Of the attorney version. Okay. So, under holidays, there is I'm in the attorney version, under holidays, B, list of holidays, and then below that, F, employees who separate from city employment and are rehired within the same calendar year are ineligible to use a personal holiday if it was used prior to separation. Yes. Include language.
So you recommend that they review it by the next meeting
Yes.
and consider adding it?
Right.
Is that noted?
Can you say that one more time?
Yes,
I got
sir.
too many versions going.
Yeah, I know, that
I'm
me
like-
too. I
Yeah,
can't keep track.
yes. In the attorney version,
Right.
on page 44 of 146, also labeled at the bottom 6-2. So it's 6 is holidays, and at the very bottom of that page is portion F, as in Frank. Employees who separate from city employment and are rehired within the same calendar year are ineligible to use a personal holiday if it was used prior to separation.
Yeah, take a look at it.
So, yeah, if
And
you want
where
to
did
take
you-
a look at
Where
it,
did you want that put into section 601 you were thinking?
wherever
Okay,
the city feels it's best.
maybe a different section.
I have a question about still section 601. Are employees allowed to take vacation prior to a holiday?
Typically, yes.
Okay. Okay, all right, so that, and there's no issues or concerns about that, and, all right.
That's the best time to take a vacation.
Pardon me?
She said it's the best time to take
Time
one.
to take a vacation. You get to take advantage and finally get to take off.
Right, see, again, section 601, eligible employees on leave of absence will receive holiday pay.
And employees that are on leave of absence without pay do not.
And that was my question.
Yeah, that's
So it,
further along in the section.
okay, so it is addressed. If they're on leave of absence without pay, it is addressed?
Yep.
Okay. All righty. Any other thoughts, comments on section 601?
There's a missing word that I'll submit separately. After, or take annual leave for any hours. The last sentence in the section, there should be a for, I believe, between annual leave and any hours. For any hours over 40 hours. Or take.
Can you be more specific about where that is?
Last
Before
sentence.
section 602. It's the
Yes.
sentence.
Oh, just before 602?
Yes, sir. Any leave for any hours over 40 in a week, work week.
Got it.
Thank you.
So, with that sentence, the thing that I had in my mind that the city might consider the way it's worded, employees whose normal work schedule requires them to work on the holiday must either work or take annual leave. When I read that as a lawyer, I say, okay, that means that the city is telling me if I don't want to work when I'm scheduled to work on a holiday, I get to take annual leave. And I'm guessing that that's not the intent of management, because management wants the right to be able to say, I'm so sorry that it's Thanksgiving or whatever, you have to come in and you have to work because the citizens need you to fix this pipe that's spewing water or whatever. So, it's up to everybody else, but I just see that because of the ambiguity there, the employee could make an argument, well, you're telling me if I'm scheduled to work on a holiday, I can get out by taking vacation, I'm taking vacation.
Do you need that power as a city? Have you considered it in that way? And do you need to be able to,
I don't think it's ever been an issue as far as I'm aware.
could it be an issue in the future? Like consider that position where you only have one employee that can fix the pipe, or is that not a circumstance you foresee? You're okay with if somebody can't come in on a holiday, then they can't come in?
Personally, I'm okay.
Is that, okay,
But what would happen is like sanitation would have a holiday, but, certain people would be off, but other people would work. And there's a
Right, they'd
provision in
have
here for if
redundancy.
you work on a holiday, that kind of thing, so,
okay.
yeah. Typically, the managers will handle the schedule.
Yeah, 'cause I
As
think-
long as the managers and, directors, what does the rest of the, I would think that if you don't want to work the holiday and they can find an alternative, then that's suitable.
Yeah, I'm okay with that. And I remembered why I asked the question about taking vacation. The language reads, employees who do not work holidays as a part of the scheduled work period are eligible for holiday pay, provided they work their scheduled working day before and scheduled working day after the holiday.
Right, but I think we treat a vacation as work time, because you're being paid for it, you've earned it.
Okay,
So you technically are being paid before and after the holidays.
so we're okay with that?
Yeah,
Okay,
I think
all
we
righty,
are.
thank you. Okay. Section 602.
Oh, so my note was correct. One question I did have going unfortunately back to the top there is like I don't know which version, but it says work shall be given the option of taking another day off within 30 days after the holiday or receiving straight pay for the holiday. Should it be more monetarily for the city? I think that was structured other places, pushing it towards flex pay flex hours rather than paying for a holiday. Just to consider, I would recommend the city consider whether they should revise the second paragraph at the end, and and make it so that it becomes flex time rather than paying for the hours. I think that was a similar premise on a prior section.
I think that's how it is right now for salaried workers. If we have to work 6 days, we get a day off. We have to work it to where there's no, of course, we don't get overtime, but the commission said that we can take flex time. If we're here to 10, 11 o'clock at a meeting, on a commission meeting, we can come in at noon the next day or plan it that week and take off. It's a flex time for us.
And this says instead that instead of flex time, you could also just elect to get paid. So I would recommend that the city consider pushing it to flex time rather than that option, if that's, it sounds like
But
that's
for
what.
salaried workers, we wouldn't get no extra pay. We would just take, but we could take the time off. It's flex time for us.
Okay, can you review that? Can I have it noted just to review that section and make sure it reflects what you're stating?
Wait, yeah, we're trying to figure out which section between us over here.
Sure, it's still 601.
601,
Eligibility for holiday compensation. Let me make sure.
Okay.
And
Got
then
it.
go down to the second paragraph, unless it's changed in this one.
part-time employees?
Yes,
Or
second paragraph and the second to last sentence, employees required shall be given the option of taking another or receiving straight pay. It sounds like that contradicts what your common practice is, so I recommend you review that and just, give an update. Did you get that? Okay, thank you. And that's it for 601 for me, sorry.
Anything else in 601? Okay, 602, I had a question. We've got annual leave versus vacation leave. Is it the same thing?
Yeah.
Okay. Next question, there's an acronym, DROP.
Yeah, that's
What is-
not,
What is DROP?
FRS calls it drop. So it comes from the state retirement system. So they actually do use that word throughout all of their language.
It stands for Deferred Retirement Option Plan. And it means that if you get to be retirement eligible under FRS, which I think is 30 years in or age 65, then you can retire on paper, but keep working. And then what happens is that money, that monthly pension payment that you would have been receiving goes into a little piggy bank for you that FRS keeps for you. And you get to work under DROP for a maximum of 5 more years. In other words, you stay with the city, you keep getting a paycheck, but you're retired. So the city's no longer contributing to your retirement because you're retired, but you still keep working. Because in the normal world, before DROP got approved, when you retired, you must leave employment from the FRS employer. But why they adopted DROP, because I remember this, they did it back when I was still with the city of St. Petersburg, back in the day, was because older people were leaving in droves at that time. They were having a very hard time recruiting, especially with police and fire, and so they were like desperate to keep people. And so this was a way to incentivize them to say, look, you know, I know you want to start gaining that lovely pension that you've been working so hard for, but you're still healthy enough, you know, to keep showing up to work. Will you please do it? And so some people signed up, and people still do to this day. And so that's what DROP means, Deferred Retirement Option Plan.
Thank you.
Great. Just in the interest of clarifying for our employees, I'd like to request that the city spell out what DROP stands for, as well as reference that it comes from a, you know, not the whole entire thing, but, you know, where it comes from, so that it's clear that you're following the FRS policies. Okay. All right. My next comment is that the city and the attorney draft document use different charts or grids. they visually look different on 80, on there's grids about years of service, annual leave accrued, minimum accrual, maximum accrual. So my specific question is, these grids look very different. Is there, from a legal perspective,
No, as long as you let the employee know how you're calculating what you're going to pay them, that's really what it's all about.
Okay.
So, remember, mine was a complete rewrite, and so I depict it, differently. I don't get, have as many columns or whatever, but if this type of layout works for the city, it's fine with me. There's no real legal
so
problem.
there's no legal
As
issues?
long as everybody can read it and understand how is my benefit accumulation being calculated, it's fine.
All right, thank you.
I would recommend that, I think annual leave, if it hasn't been considered, using the word vacation leave, I think the attorney work product, it took me a while to figure out what that was when I was reading, so for consideration, I don't think it's a requirement, but I would recommend you look at the word annual leave and consider changing it to vacation leave. The other, I'm going to request that the chart that you're referring to, the chart has a mix of days and hours per month. I think that could be, it would make sense to have the same, sequencing throughout that entire chart. When you get down to 21 years, it only does it by hours. Although maybe I'm not understanding correctly, it seemed confusing while reading it. So I recommend that the city notes that and considers if there's an improvement that can be made to that chart to make it consistent.
Yeah, also, in the attorney draft document, there's a reference to moving unused vacation time to sick time.
I wrote that down also.
Yeah. Is this best practice? Is it permitted by the city? I think it's got implications about payout and so on.
I don't think it's necessary to change.
Yeah, I don't
No.
think, I
Not
can't figure out
necessary to
why we would need that.
So that you don't have to pay out money at the end of the year for holiday.
Right.
So you would rather give more days, it's rollover. You get more days the next year.
Yeah, but you're capped.
Yeah.
What was that?
You're capped.
Oh, so I don't fully understand it. Do you have any?
Well, you're capped, but a lot of people burn both types.
Right, so, by combining it into PTO in essence, because is your sick leave and all that combined? So you can roll it over into, you're saying you can have a cap, but you still may be able to roll it over below the cap?
Yeah, if you, are you talking about that you can, at the end of the year, put unused sick into vacation?
Your
Yes.
document talks about vacation to go to sick, the other way.
Because if you, under the policy that I have, you can't take vacation for sick. Vacation's supposed to be taken for vacation and sick's supposed to be taken for sick. And so if you burn down your sick in a given year, you might want to have the option to roll that over into the new year if you've got an ongoing health issue that you know is going to require you to continue to take time off for chemotherapy or whatever it may be. But it's just one model of many. So, I think if the city's comfortable with how it does, that's not.
Always worth considering and discussing. So how does that relate to your policy? Are they mutually exclusive buckets, sick and?
Yes.
So it's the same as HIT is?
Yep. And we do allow employees that are on extended leave, like FMLA, if they're out for 12 weeks, to use vacation.
So would the city want to, so I think it sounds as though yours are separate buckets and you can, so FMLA, this would be allowing them to roll over their vacation into the next year if they depleted their sick and using that for additional sick days in the following year if they haven't used their vacation. So it's just an alternative option to consider.
I mean, you know, if somebody's truly sick and they have the hours sitting there, I mean, we believe they should be able to use them.
Yeah, they're already allowing that for those exceptions.
So then the policy should reflect that? What are you guys understanding?
Doesn't it say that vacation, what does it say about vacation that's not used, the current city policy? If you don't use your vacation, what happens to it in a given year?
You can bank it.
You can roll over so many, a whole
Yeah.
year of it.
Okay, but as vacation time, not sick time.
Correct.
So this language is allowing you to have an option that if I do have an illness and I've got extra vacation time, it's allowing me to put that vacation time into a different bucket.
So I would
That's
like
my understanding.
to also, what I read does not say that you can roll it over. Is that what you read? My reading this, accumulated annual leave will be tracked on or about November 31st of each year. Notices will be sent to have excess leave. Employees may cash out accrued hours over the allowable amounts, or it will be forfeited.
Correct.
So that does allow for rollover?
Well, no, you can roll over, so if you look at maximum accruals allowed,
That's what that is.
that's the most you can have. If you go over that, then you're paid out for that.
Okay, so he's saying that they are allowed to roll some of it over. Okay.
Yeah, it's rolled over up to that limit.
Okay. My thoughts are, since we have these separate buckets and you're managing the buckets, if you have an employee that has used up all their sick time, but they have vacation time, you're allowing them to roll over the vacation time into the vacation bucket. But I'm sick. I need more sick days. I'm not going on vacation because I'm sick. So I believe the language that the attorney had proposed would allow our employees more flexibility, that you've got an option that if you're over it, you can put it carry it over, instead of into the vacation bucket, you can move it into the sick bucket.
So why don't we?
Rob, was that your intent with that language?
Yeah, I think it's probably best to just ask that they reread that.
Yes.
Okay.
Because it's unfair to make them like give an opinion right now, you know.
Yeah,
that-
I would
so-
say consider, and then let's revisit next meeting. And I think that that's something to consider, is the ability. I think it may be beneficial to everybody.
Right.
It
If they
sounds like
find-
you sort of consider that anyway.
If they find any merit in it, that the next draft, they will recommend a change. If they don't, then the next meeting, they'll just articulate briefly why they wanted to keep it as it is. That's-
Perfect.
Because I think what the option is now, like you're saying, like if you're sick for 2 weeks, you have your doctor's note, whatever, you're allowed to use vacation time to be paid. It's automatic. I mean, the option is there.
Okay, so why don't we consider, if you don't mind rereading those two sections, the sick and annual, and consider if it reflects the current policy as you see it, and we'll discuss at the next meeting.
Sure.
Just make a note of it and we'll discuss. And some of this is learning on our part because we don't know all of your
Oh, I understand.
procedures. Yeah.
You know, but I haven't been here that long either, so I'm still learning, so.
Oh, a minor one for review in the end of the section of 602. It says, will paid to the employee's estate or otherwise defined by law. I guess it covers it, but I thought the word beneficiary or something like that may be appropriate.
Well, no, I mean, Rob can probably comment on this.
I think his,
Typically, you pay the estate,
Okay.
then the estate pays the beneficiaries.
Which section are we looking at?
the language, I may be incorrect on this, at the end, last sentence in 602, can you read that language and see if that adequately encompasses the process in the event of employee's death?
Yeah, I don't have mine in front of me, but I think mine had a bit more detail about how it it would be paid out. So, I mean, what's here isn't illegal, and, you know, it would eventually work out, but, you know, I think mine's a bit better for staff to read in those events when somebody does pass away.
Please consider reviewing the attorney's version in this last sentence and see if there are any updates you recommend.
Okay.
Thank you.
Christine, are you talking about the forfeit vacation payout section?
Okay.
Or,
Well, this was 602. You're asking which section was this? This is the last sentence of 602.
It's
and-
employee's death.
Yeah, if someone dies, what happens to
oh,
the?
okay,
to the-
Correct. This is the
Because-
reason each one of us have on file who our beneficiary is.
Okay, thank you.
I would also like the city to consider using the attorney language about, it just clarifies, employees shall forfeit all vacation payouts under this section if if employment terminates because the employee, and then it lists several things. I would like the city to read that. In the attorney version, it comes under section 7, leaves
Okay.
of absence,
Ooh, yours.
vacation leave. It's the page 46 of the attorney document. I just think that if somebody is expecting to get paid out and they don't get paid out, we should have it in writing ahead of time so they understand that if they did any of these things that are stated,
So
you're not going to get paid.
They do it by separation agreement, I think.
No, we don't do separation agreements.
We have to separate, they're ours.
Well, not that I'm aware of.
There's been employees here that they did in a separation agreement. Oh,
Well, a separation agreement is completely a side issue. The issue is, if you have a payout provision in your benefits, then any and every person who separates gets to have that payout. And so the point of this language that I'd recommend to the city is, you know, we involuntarily take from taxpayers their money to run this government. And it is offensive, in my personal view, to have someone engaging in these types of inappropriate criminal activities or whatnot to be entitled to take away anything more than what they worked for and are legally entitled to. That's why I recommend it. But if you're going to take that position, you really need to spell it out, because otherwise their lawyer's going to be here with their hand out saying, the policy says I get paid this out, and I don't care if my guy just embezzled you, he still is entitled to this payout. So, you know.
well, what I've seen in a separation agreement, it just states exactly what's in here that they're entitled to. It doesn't give it all to them. No, there's no special favors. It's just that there's
Yeah.
under some, depending on how they left, you know, the 20 weeks vacation, the 20 weeks severance pay or whatever, you know, because that's a different agreement. That's a different document.
That's, and I'm glad that you do that, and that document should match language that's in the manual, and I'm recommending that the city incorporate the language, or at least review it and adjust it and consider what's in that separation document, but that we be proactive and not wait until somebody is leaving and saying, oh, by the way, here's your separation agreement. I want them to know upfront and ahead of time that if you do this, you're not going to get your vacation time.
And what?
I did want to mention, like, if you look at the Article 11 on separations, it does say that if you are, let's see, blah, 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 failure to comply with the procedure, cause for denying employee future employment, as well as forfeiture of all leaves and negating normal compensation for unused sick leave. So it does say that. Page 36 of today's packet, under Article 11, separation, under the resignation. But I do agree that it could be clarified here in this section as well on benefits, so that you have a heads up if you are, if there's an involuntary separation, you shouldn't expect these. But it is also mentioned under separation that you're going to negate normal compensation for unused sick leave if you're separated.
Yeah.
So the recommendation is the city reviews what and considers the attorney's language. So review section 1101 and back in 602, right? And then can you refer to the paragraph of 602?
It's just that when I don't have a specific paragraph in
Okay, in
602.
general,
It's just that it was,
not mentioned.
it was lacking.
Okay.
You know, going back to my first comment, that there's 30 pages in the attorney version, and I was trying to willow down to what are some of the biggest areas of, I don't know, difference.
So I think, if I could crystallize so that Mr. Lilly understands, what I believe you're saying is you would like the city to consider the language in the draft that I had done as to vacation payout and leave payout, because it occurs at the end of both of them. So where you describe what their payout, in this document, where you describe what their payout otherwise would be, then add a new section that says, however, if the reason you leave is for one of these articulated reasons, you are not going to be getting any payout. That's what you're asking them to consider.
Yes,
Well summarized.
thank you for clarifying my rambling.
And I have a general comment before we carry on, but I want to make sure that Sean's had a chance to catch up.
I'm
But
trying.
You're trying, yeah. Are you okay to?
Yeah, I'm good.
Okay. A general comment is the formatting. Is it possible to utilize track changes and also?
That's the way it was originally done, and I guess, Claire, you thought it was better to do it this way, right?
We changes, even our city attorney uses track changes. It lets the Board of Commissioners know what, as we work through the document, what's changed.
No, you're doing strike through.
Oh, track,
and not-
yeah,
Yeah,
oh,
but
yeah.
it's not track changes, that's different.
I'm sorry.
Yeah, so track changes is a function, and so it's difficult, I have a few general comments, I'm sorry to commandeer, but it's very difficult. It can be difficult to read with all the changes and not to know what's real or not.
Well, I mean, it might help, the blue is new, the green is your input, and,
I would just ask, consider it if it's able to be done in a Word version, because it's easy, it's a pretty good function. So I would consider that, but also that the attorney's version does have paragraph numbers, even if it's temporary to facilitate these conversations, it might be nice to do. What do you guys think? I mean, I think we're having a hard time indicating where we are. But is that, how does everybody, what are thoughts on that? I think that it could be beneficial to have some additional structure. Do you guys agree, disagree?
I think we can refer to the section.
Okay.
I'm afraid
We're
it
okay
might-
with,
Like section and paragraph. I'm not sure about the track changes, because then then there's like a lot of stuff happening. So we have like the
Right.
language and we have the strike through. I mean, as long as, I think for me, my issue is I do have a lot of documents now, so I'm like, and I have notes on the original one that we were given, but then every meeting we've got like a new version, because we've got the most recent changes. But at the same time, I think, I'm not sure that having extra text over here would help.
oh, so
Because we put that in
I'm
the
not
minutes.
referring to the comments. To me, I would love to be able to just look at a clean version and read it in the way that it's without the outline strike. And so we can probably move through this if it's not, it sounds like I don't have a consensus.
We have to present it to the Board of Commissioners
In
in
this
the
way.
strikeout and underline format.
Okay.
To let them know what has been changed and what they want to reverse or add or.
Okay. We can
I
carry on.
agree, and I think we, just ahead of us, have a large body of work that once we've gone through each thing, to go back and read everything and make sure it's incorporated. And I see that as being a huge task that lies ahead, but,
Okay.
we'll schedule time and we'll get through it.
Okay.
Any other comments on section 602?
No.
No? Okay, let me open it up for comments on 603. I noted 3, but I'll let others go first. Okay. Okay. I noted it on page 603. The city version has 1 page, while the attorney draft version has 5 pages. What prior discussions have taken place between the city and the attorney to discuss differences in best practices? So, Rob, I guess I'm putting the spotlight on you. So far, are you comfortable that the 1 page, excuse me, the 1 page city version is complete enough to cover us from any risks?
Well, again, I think this just loops back to the conversation we've already had. I've recommended what I feel to be a robust, more comprehensive set of procedures for all the topics that we're going to be covering. The administration has looked at them. The administration has decided to stick with its own model. So we're at a point where, you know, we're working with what they have. And I'm at a point of just trying to point out things that are of the most dire concern. For 603, you know, I'm going to defer to you all first, but, you know, the whole issue on excessive use of sick leave, I need to provide advice for that when you all are done for putting in your...
And excessive, okay, so you consider us, that perhaps that area we are at risk under excessive use of sick leave?
It is completely antithetical, in my view, to discipline an employee for taking sick leave. Think it through. I am an employee, and I come to you and I say, here is my sick leave request. You are my boss. You may either approve it or you may turn it down. If you approve it, what does that mean? It means you have looked across your organization and said, I can spare you, right? And you have time on the books. And so I approve. Now, a month and a half later, you call me into the office and say, Rob, I am disciplining you for excessive use of sick leave. Why, boss? Well, because you took all this sick leave. But boss, isn't that your signature on the approval thing saying that I was allowed to take that sick leave? It is just not good management practice. If the boss believes that sick leave is being that is asked for a bogus reason, and employees do, they abuse, well, I'm going to go to Disney World, but I don't use my vacation, so I'm going to say I got the flu or whatever, which we caught one time because the stupid lady posted on Facebook of the pictures of her, you know, her family. But anyway, so, you know, you deal with that. You tell the employee, no, I'm not going to, I don't believe you're sick enough, or we can't spare you, you know, we're dying here. We've got 3 other people out, you know, and I'm sorry you have a cold, but you got to come in. We got to get the mission done. You do that. But if you approve it, why then are they worthy of discipline?
Thoughts? And so I'm going to recommend, instead of asking him what the preferred language is, we have the preferred language. When we go through these, we might ask you what your biggest sticking points are, section by section. And as you just did explain to us, you know, that's really bad for whatever reason. So I recommend that we proceed in that fashion. And so thoughts as far as, I would think that would fall on Sean, right? How do you feel about that?
Well, in the scenario that was talked about, I think the supervisor would be in trouble.
Right. So he's saying that it's contradictory almost. If you're approving the sick leave, then it can't be excessive. So I agree with that. I mean,
me too, 100%.
So it sounds like we should not be able to discipline individuals for excessive uses of sick leave because either you approve it or you don't, but if you, after the fact, cannot discipline somebody.
And we can ask for a doctor's note anytime. Huh?
Although the policy says unexcused absences, it doesn't say that they're excused.
I mean, sick leave would not be unexcused.
You can't take sick leave unless it is excused. It's just not, doesn't fit, right? If you're going to get paid out of the sick leave bank, it is because the city has said you are entitled to be paid out of the sick leave bank. Now, if you just say, you know what, I'm sick today and I'm staying home, and the boss says, no, I need you to be here. Well, okay, that's unauthorized, but you're not going to get paid for it, one, and you may well be disciplined for insubordination because you were told to show up for work and you didn't show up.
So I'm recommending everybody reviews that and we consider it for, because it sounds as though it comes from maybe experience or somewhere of, where we might really want to consider this one to prevent.
Well, the experience is, and I'll just say that the problem that you run into here is that the person ends up, the same people that tend to abuse sick leave or whatnot are also, not being general, but tend to also sue the employer if it gets to where they're about to be fired or whatnot, and they call a lawyer. And so you get a situation in this kind of thing where you're disciplining people for taking off sick of, oh, you're engaging in FMLA retaliation or ADA retaliation or whatever because and then they'll look across the organization. Okay. And they'll say, who else has taken off this amount of sick leave time? Right. Did you discipline them? Right. Well, no, we didn't. Well, why not? It's because you're retaliating against me. So the rule just needs to be, if I get approved for sick leave, I used my sick leave. And it's not excessive, blah, blah, blah.
Is that?
If somebody is being disciplined, it comes to me and the city manager before anything's done to the employee.
So
this paragraph, the next to the last sentence says, you define what excessive is. Excessive is defined as 3 unexcused absences in a 3-month period. Or, 1 week-long bout with the flu would be considered 1 absence. So am I understanding that you're going after people, you're considering it excessive if people take 3 unexcused absences? Is that?
Yeah.
Is that, that's the intent?
So, and I compared that with the attorney's language, and I believe he has a similar clause. I initially was asking myself if that was legal, but I think it is. You have a similar one. It's 2, but you use a different term, voluntary resignation versus something else.
That's a separate issue.
And
even there with the unauthorized, that last paragraph, unauthorized absences from work for a period of 3 consecutive work days may be considered. That's not really even sick. That should be in a different place where it is in my recommendation of ways you can be separated, because really that's just, and it could be like one time we had a situation where the employee had gotten arrested and just didn't show up, no one knew where he was, calling around, finally discovered, oh, he's arrested. Well, the county invoked that particular provision to say, you're deemed to have resigned your job, we're just writing, and you send him a letter, and that's a clean way to do things. It's called job abandonment because there's no due process that needs to be provided in that case. They're just deemed to be lost their job. And if it comes to pass that they say, well, guess what? I've got proof I was abducted by an alien spaceship. Well, here I am back, and
You're
I didn't, then you give them their job back and all is well. But, it's usually if they're just like disappear, it's because they're on a drug binge or they're, we don't want them.
So I agree with that. I think it's a lot more intuitive if that's with separations. I also think there's not, and that's jumping ahead, but I'd like to consider the unauthorized absence being moved. So the second to last paragraph in 603. And so I think that's a separate issue, but dealing with the sick leave, should we allow everybody to review in more detail and come back to that next meeting?
I would especially encourage our subject matter experts, Sean and Rob, to have some discussions on this and report back.
Can we recommend a meeting on that topic that or is that not?
You can recommend what you want to. We've described it in the past. I've met with a prior manager, I've met with the current manager, Mr. Lilly, I think was in the room once or twice. That the management team is aware of my recommended language for all these things. They've added some provisions of what is in mine in this document, but they've made the decision to recommend to you what is before you. And so
we're working through it, so I would say let's, and it's a little painful, but I would say if we can, specifically the sick leave and vacation leave, and it seems as though, it may be beneficial to discuss the options for sick and vacation leave, because it seems like there could be benefits to improving that part. I think there's a desire to stay with this version, so we work within that, and if there's a specific area that, we think needs more attention, it seems as though this area may, sick and vacation leave, we seem to have been stuck here for a while. I'll leave that to them, but then let's plan on revisiting that next time.
Agreed.
Okay.
Yeah.
I just want to let you guys know, I have another commitment at 12:30, so it's 11:48, so.
I'd like to recommend that we get through section 6 if we can, and then start afresh with section 7 at our next meeting. Is everybody okay with that, even if we go a little
I think
beyond 12?
we'll get through it.
I also had budgeted 10 to 12 for this meeting, and I have another meeting that I need to get to as well. So I was just looking through this section. There's actually quite a lot of section 6
Yes.
left. It's a pretty big one.
I only have 2 more comments in section 603. In one of the versions, it says the department director may require, I believe it should be a consistent citywide policy that after X amount of sick days or whatever, a provider statement is required. So I request that you say will require instead of may.
Are you talking about for a sick note?
Yes.
May I provide you advice that I wouldn't recommend that? Because, so there are some instances where management does have to balance efficiency with equal treatment and so forth. And so I get where you're coming from with equal treatment, but there are circumstances where management clearly knows that the person is sick and is entitled to use their sick leave. And so if management's comfortable with that and the employee has been a good faith employee and has never abused sick leave and in a situation where they just got COVID or whatever, it doesn't really make sense to make them get in their car and go to a doctor's office and pay a deductible to get a sick note if we believe that they are sick, right? So getting the sick note, I think we should leave it as at the option of management, just because it's an inconvenience to employees and an expense to an employees. And in a way, if the employee is that sick, we don't want to make, because you can't get a doctor note unless you go to the doctor. And so that means they got to get in the car, go pay a fee, just to get access to sick leave that we didn't believe that they weren't entitled to anyway.
Every place I've worked has just said you need a sick note if you're out more than X days, X being 5 days, 3 days, whatever that number is. Clearly not for every absence. I understand where you're coming from. If the city is comfortable.
But we're small enough that, we know who's really sick and who's not really sick,
You're like the Santa Claus of employers.
But I mean, no, what I'm saying is, if somebody's truly sick, we know it. Because we have to figure out how to fill it, and we know what's going on.
Yeah, and remember, every time one of those notes comes in, because we're a public records agency, it's got to be stored permanently someplace, so.
I am happy moving on. My last comment, we had discussed at some meeting that there is a policy for donating sick time for another employee. Is that covered somewhere in this document?
The requirements are on the form.
Sorry?
There's a form that has to be filled out to donate sick time, and the requirements are on there.
Should we not include language covering that so that people are aware that that exists? That option?
There is a transferring somewhere.
In some places that I work, they could donate extra hours, not a limit. It all depends on what was wrong with them, had cancer or something like that. People could donate a week.
There you go.
I guess I would expect to see that language under sick leave.
Check page 51.
Page 50.
1112, was it? Oh, 1212.
It's somewhere.
Okay, if you say it's in there, it just, to me, seems that it would be logical under the sick leave policy, but if it's there, I'm not going to take time, and I trust you that it's there.
1212 is donation of sick or annual leave.
Okay, so we didn't get there yet. Okay, all right, thank you.
if you've done your two, can I add one that's a quick one, hopefully? Do we have in here like a disability, light duty work and information on that included in this version?
We do under the workers' comp temporary duty.
Okay, I'll look into that.
If somebody has a disability, we're required to accommodate the disability unless it's an undue hardship. That's under the ADA.
Do you think we could maybe put that section 1212 into the sick leave section? I mean, maybe once we get to the miscellaneous, like there was a bunch of miscellaneous sections
Yeah.
that actually would be better in their actual section that were probably added on later, but now that we're like doing our wholesale reevaluation, we just, I mean, we can get to them when we get to them, but in this case, since we know section 1212 is donation of sick leave, just add that back into section 303 sick leave. I mean, I'm making a motion, I guess, to suggest that.
So I did work on, like, so I did everything and track changes on the version on my computer and also moved those into the appropriate sections as I thought they were. I didn't know, I was behind schedule, but I can send that, and if we can send that out and see if people, it's a lot to digest, so I would send it, and if you can share it with everyone, and we can consider if those are the right sections for those miscellanea.
Thank you. Anything else under section 603?
I'd like to just make an inquiry as to how far an employer can inquire into an employee's state of health. Does anybody have an answer for that?
So if an employer provides sick leave as a benefit, then the employer is allowed to require the employee to provide sufficient proof that they are eligible to use that benefit. That's why some employers, again, just say, we're not going to do sick leave anymore, we're going to do unileave, and whatever reason you take off, you take off. So that's step one. If the employer says, employee, I need a letter from your doctor explaining what's wrong. Because a lot of times as an employment lawyer, and y'all are probably familiar with this too, employees go to their doctor, and a lot of doctors, unfortunately, just hand out notes that say, was seen by me today, or unable to work. It provides the employer no information of why they, but even if the boss goes back and says, I need to know why. What were you diagnosed with? Do you have the flu? Do you have COVID? And the employee brings that back. Under the Public Records Act, there's a records exemption for this. We got to keep it because it's now a public record, but somebody can't disclose it. Now, when you get into Americans with Disabilities Act and Family Medical Leave Act, there are more detailed regulations about what the employer is allowed to do. So let's say Family Medical Leave Act, there's a form that the federal government has promulgated, a certification of healthcare provider. And that certification of healthcare provider has like 6 things that they fill out, of who's the employee's name, when were they seen, what is their condition. So they are required to say what is their condition, what physical things can they not do, right? And how long is the condition going to last, and is it going to be chronic or not? The doctor answers all those questions and signs the form. That then comes back to management. The FMLA regulation says that, and this is kind of similar for ADA as well, only those managers with a need to know in order to make the management decision to say, yes, FMLA is applicable or not, they're entitled to see that, but your coworker is not entitled to see it. It shouldn't be handed out because that, number one, it would violate the records exemption. Number two, it would violate the federal regulation. And number three, there's at least one Florida case where the right to privacy was accused because the boss got the AIDS thing and immediately began handing it out to all the coworkers saying this person has AIDS. This was back in the early 90s. So does that answer your question?
Well, does that become part of the employee's record?
So under federal rules, and Mr. Lilly is well familiar with this, the employer is required to keep medical records in a separate locked file.
Got it.
So that's pulled out, so anything that's medical goes into a separate file in HR. There's a lock on that file that complies with the regulations. If anybody does a records request, we would say those are either redacted or we're just not going to give them to you because they're exempt.
I assume there must be some protection in that regard.
Yeah, but management is entitled to ask what's going on because a decision has to be made. You know, am I good? Do you need a reasonable accommodation? Well, I need to hear from your doctor that you do have heart disease or whatever. I can't just believe you, you know, but the trade-off is, okay, if I'm your employee and I give you that documentation, you got to safeguard it. You can't just hand it out to the world to see because that's my personal medical data.
Right, right.
All
So, how
all
about like
FMLA forms come to me. They don't even go to the supervisor.
If, let's say you observe an employee, some guy climbing on a tractor or something, and you see maybe he has a problem of back pain or something like that, are you permitted to inquire?
No.
You're not, I assume?
Well, you're permitted to do whatever you want to do, but my legal advice, and I'm sure Mr. Lilly would agree, is that we assume our employees are healthy, happy, and able to work. That's a lovely little phrase that I always teach. And so if an employee has a medical problem that is causing them not to be able to perform the essential functions of their job, it's on the employee, and somewhere in my policy, I've got that written out in the ADA thing, to come forward to management and say, I've got an issue, boss. I'm having a hard time getting on that tractor. Here's the situation. I really don't want to broadcast it to everybody.
Yeah.
And so then it's up to, there's an interactive process under the ADA to say, you know, is there an accommodation that we can give you that would still allow you to perform the essential functions of your job, but still accommodate this disability? Sometimes yes, sometimes no. But if getting on that tractor is an essential function of the job, and their back problem has gotten to such a point that they just can't do it anymore, they're not eligible. They can't meet the essential functions. And so if there's no place else for them to get a job in the city, management would have the right at that point to move them on, because we're paying a wage to get that particular job done.
Reasonable accommodation, that particular person might need a step stool to get up there.
Yeah.
You know, that's
Right.
easy.
Right.
But it's, I pretty much understand you can't really ask a disabled person why they're disabled.
But why it's a real danger for management to affirmatively ask, like to look at the guy and say, oh, he seems like he has a problem. Let me ask, dude, what's your problem? Is because under the ADA, there's a separate cause of action for perceived as being disabled. And so if the boss, thinking he's being friendly or she's being friendly, and goes and says that, and then, you know, weeks later the person gets disciplined or fired, they're going to run to their lawyer, and their lawyer is going to say, well, did they ask you anything about your health? Well, yeah, they asked me if I was having back problems. Aha, here's another lawsuit. You know, that the employer perceived this person as having back problems, and that's why they fired him. And so now we've got a whole claim. Yeah. So management assumes their employees are healthy, happy, and able to work unless the employee comes forward and tells them otherwise.
So should we choose a stopping point and figure out next meeting and all of that? Or what is our next meeting?
Well, I've got one, if I might just address a question in 604, and then it should be quick. It's a very short section, and then we'll talk about next meetings, et cetera. My concern about 604 states in this policy that the city gives insurance at no cost to the employee. And that's a good thing, but considering the rising costs of health care, we might need to change that.
I had that circled too, and you know, my counsel to my clients always has been, you can have a general statement about that we're going to try to provide you with a suite of benefits, which may include blah, 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 but a benefit package year on year can change because of inflation, because of availability of policies. So to come into the policy and just proclaim at no cost, that's a big commitment. Can the city do it? Yes, it can. I think that the city should retain flexibility to back that out, and that's part of the annual budget process that the manager brings forward, of what are we going to do for our employees this year?
Agreed.
Where our commission has already been discussing that, and they're agreeable to how it stands right now. With the last meeting of the budget will be at the end of this month.
But if we remove at no cost, I think that covers it.
Right.
Right. Perfect.
Because right now it is, I mean, it is at no cost.
Yeah, it's reviewed every year, too.
Yeah.
But next year, it might,
It could.
Yeah.
it could have,
Yeah.
and so I.
And
Sean,
this
you-
document is adopted by ordinance, so if you change it, you have to go do a whole ordinance to pull it out.
Right.
Otherwise, someone's going to sue you saying,
Yeah.
I'm entitled to at no cost. It says so right here.
Right. Yeah, the commission revisit it every budget
Okay.
year.
So if you'll just strike at no cost, I'm good on that. If we can agree that we need to resume section 6, starting with section 605, and I would request that the city be amenable, that if people now have the opportunity to go ahead and review the rest of section 6, and also the next couple, please submit in writing before our next meeting. Now, let's talk about our next meeting. At our last meeting, we discussed the fact that while September is an arbitrary thing, we need to make a decision. Are we going to add another session so that we can meet that date? Because we are getting pretty far behind.
I
Or
don't
do
think-
we push back the due date?
We pushed back the due date. I think we're doing fine. I mean, in my opinion.
Okay. Rob, if I could put to you, if we extend this beyond September, and let's say we go to January, is there anything that you see that could put us at tremendous risk if we delay? I know you don't like to hear this, but I mean.
No, he's saying all of it is what
Yeah.
he's saying. So he doesn't, that's a tough question to ask him. I would say.
I know.
The answer I'm going to give is that it's always better to improve your policy sooner than later. But the sooner you do so, the more you cut off potential claims. However, Mr. Lilly is on the scene now, and he's got a better handle than prior about what's going on out there. He's got a better opportunity to cut off claims, before they get to be a full-blown lawsuit by making things right. So, and in instances where there are significant issues, management will call me and I'll help as well. So I think it's better to me that we try to get the document as good as possible, even if that means we have to take more time to do it.
Okay. All right. I guess I'm in the minority. I want to get it done. I want to.
And also, when it goes to the board, it's about a 3-month process before it's adopted.
And I mean, I would be fine with another meeting. I mean, we have a lot still to do, a lot more conversation.
So our next meeting isn't for a couple of months.
Paul and
I'm okay.
I have November 17th.
About that meeting, I did not reply all to that email, but I had mentioned it in a one-on-one with the city staff. But I'm teaching Tuesday, Thursday class, so the Thursday at 10 would not, I would probably need to leave here by 11. So
17th.
on the 17th.
Of November.
Yeah, so I could do it earlier, but I definitely would need to leave a hard time by 11.
Oh, thanks for good. What do you think? Well,
Well, let's take our first decision. Do we add another meeting to continue our momentum? Or do we just carry on? Our next meeting was scheduled for 3 months from now. Go in a 3-month increment.
I would think add one. Paul?
I'll be here. Where can I go?
Retired.
What's your preference?
Maybe one more between now and November.
Okay,
It seems like a long time by the time you.
yeah. Is the city amenable to a meeting prior to November? And then we'll discuss changing the November date.
Yeah, probably October. Yeah,
Yeah.
and if,
I'm not available in October until after the 10th.
okay, and I'm gone from the 18th to the 25th.
Everybody good with the 11th?
Judith
We
Ann, you're
avoid-
teaching.
Yeah, why don't we avoid Tuesdays and Thursdays if we can, just for this, like the 12th or the 14th?
Okay, if it's a Wednesday, it has to be starting at 11. 'Cause I'm only part-time, remember?
It's okay.
Okay with me.
I'm good.
Wednesday, October 12th at 11 a.m.?
Can we commit to working longer than 12?
Yeah. Yes, I can
2
till
hours?
1. I think 2
That's
hours
11 to
yeah.
1.
is a good chunk.
Our Board of Commissioner Day, tonight.
You want to do the 14th then? Or,
I won't be here.
Well, we're not going to be interfering with the Board of Commissioners. They're not.
No,
Their
it's usually
evening
that
or-
night.
I
Yeah,
think
they're-
if we're done by 4 o'clock, we should be okay to set up for the BOC meeting.
We better be
Okay,
done by
thank you.
4
We'll be out of here
o'clock.
way before.
okay,
11 to 1, right?
11 to 1 on the 12th. And now let's take a look at November. Does the 16th instead of the 17th work, so we can respect Judith Ann's teaching schedule?
Oh, that would be amazing.
It's okay with me.
The what,
Okay.
16th?
The 16th of November.
10
instead of
a.m.
7.
still on a Wednesday, or Sean, do we need to?
11, it has to be 11 on Wednesday.
That's okay.
So 11 to 1.
That's okay with me.
11 to 1.
And
And so can I please reiterate my request to folks that you go through the rest of section 6, 7, 8, and 9, so that we're staying a little bit ahead of things, but understanding that 6 is pretty aggressive.
Yeah.
And so, Paul, I hope I'm not telling tales out of school, but we were chatting ahead of time, and you mentioned it would be difficult for you to submit comments electronically.
Yeah.
If Paul were able to just write down thoughts ahead of time, would that be acceptable to the city?
and submit it and scan it, and he could drop it off to the city, or? I don't know.
Well,
Yes.
yeah. I guess I'd accept them anyway, I sent them, but
He does,
they use a tablet, so.
it'd be
you need to
difficult for him to mark up
correspond
the
to
document on a computer, but you could take a picture, Paul, of your notes and,
Yeah.
yeah.
Just bring it to me and
Yeah.
we'll include it.
Larry Gifford.
Thank you.
May-
Thank you so much for your flexibility.
I'm
Because
happy
I
to
think
do
it's
that.
helpful if people have a chance ahead of time.
And I'm going to try and submit mine. Can I have one other request that I thought of? Can we try putting the document on these screens maybe? So as we're, are you controlling
it's
that
over here.
screen?
I am not well versed in this one, so Robin has been doing it in the past, so I apologize that we didn't do it today.
The moving?
Oh, we were going through it on the screen.
No,
Like
we
I'm
weren't.
saying as we go, we're, like having,
There, yeah.
I'm having a hard time
Oh, look, we're
following
done.
with all the versions.
Yay!
He's doing it, so it might be easier if we could all just look at the same thing on the screen.
Well, would one of you guys, well, I have to take all the notes. So I'll do my best.
We might be able to, we'll figure something out, but let's consider it for the next meeting. So we can
Robin
all
will be here
looking
for
at-
the next two meetings, and
yeah.
he'll run that one.
Thank you, yeah.
Thank you.
So if you said October 12th, is that right? Our next meeting?
At 11
11 to
o'clock.
1. Okay, so if the meeting is October 12th, when would we be needing to send in our comments?
For the stuff we already worked on or the stuff going forward?
The stuff moving forward?
Oh, okay.
So if
About
we,
middle of September or the third week of September would be helpful. We need them at least a week before we do the packet, 2 weeks before the meeting. So that, it'd be about 3 weeks before the
three-
meeting.
okay,
And once you
so-
submit them, I need some time to go over,
Yep,
so.
just give me a date. If I have a date,
Tell me what I'm looking at, because what happened last time was I was overseas and I didn't have my notes with me, and I was like, sometime
When we're meeting?
middle of July, and I'm like, I'm not, I wasn't thinking about a middle of August meeting when I left the country, so I just want to make sure, if I have a
Need to
deadline,
research.
I'll meet it, but,
Would September 12th work?
all right, hold on, September 12th.
could we move it to the 15th, please? I'm out of the country.
Yeah.
Oh, I'll be out of the country on the 15th.
Well, that's
okay,
just to
let's see.
submit by, right?
That's
So
a
if you can
submit,
do it by
okay.
the 12th, that'd be fine.
What am I worried about? I've already done mine. Never
All
mind.
right. Yeah, you're
It's
ahead of
fine.
the game.
So this is comments on 6,
6, 7, 8, 9.
7, 8, and 9.
I'm an optimist. Any other further business to discuss? Okay. I appreciate the discussion and look forward to getting the minutes in 2 weeks so that it's fresh. We covered an awful lot of ground here, and so I look forward to seeing it in writing. So, thank you. Any other questions, thoughts?
12.
Okay. Do we have a motion? No, I don't need a motion. I can just close the meeting, right?
Just
Okay.
close the meeting.
We are closed, 12:13.
13.